Okay, Congressional, for the record. Mr. Speaker, my original piece of legislation was a proposed amendment to the U.S. Constitution to require a balanced federal budget. This bill is sponsored by Democrats and Republicans and is not a partisan issue. The bill is in keeping with the wishes expressed by voters from across the country. The electorate has spoken. It is time for Congress to act. The bill is one of several that has been introduced on previous occasions. The bill reflects a sense of national priorities expressed by voters throughout the nation. As we are entering the 113th Congress, I sense an even stronger national mandate for government to limit spending. The people want to see their representatives exercise a more cautious hand when it comes to taking care of fiscal responsibility. Out of control spending by Congress must be stopped. Today I'm introducing a proposed constitutional amendment to require that the federal budget be balanced on a yearly basis. This amendment requires that the federal government limit spending. This amendment does not require additional taxation of the American people. Once ratified, my resolution would require the gradual reduction in deficit spending over a 2.5-year period. This would require the cooperation of all branches of government to work together toward this common goal and for the good of the American people. My resolution would prohibit federal expenditures from exceeding revenues in years to come. This is a simple amendment in its wording, and I recommend its adoption. For too long, this problem of spending by Congress has been a sore point for every American. If you think back in recent memory, how many of this nation's presidential candidates have sworn to balance the budget and reduce federal spending once elected? And how many candidates once elected have actually succeeded in the task? None. This proposal is long overdue. We need to tighten the controls on big spending and big budgets. We need to get a rein on spending, and more spending. Money doesn't grow on trees, as we all know. As critical as the need to reduce excessive government spending and to eliminate the deficit was 5 years ago, it is even more critical in today's economy. We have been confronted with double-digit inflation. We have seen the stock market in its rapid ascension, and then we have seen it rapidly descend. The country needs financial stability in order to continue to compete in the world market. This resolution will help to stabilize the economy. The majority of Congress has given support to this measure for a balanced budget. 35 states have already signed a declaration calling for a constitutional convention to draft an amendment to balance the federal budget. The time is now. The voices should be heard. The people of the United States of America have demanded action. This Congress must respond to their pleas. It is the job of every elected official to exercise fiscal responsibility. Cities, counties, and states must operate with a balanced budget or go out of business. And we have witnessed in recent history some areas of the country are bankrupt from overspending and exercising no control over state and local budgets. The U.S. government must begin to operate with a balanced budget, a budget that serves the needs of the nation without overspending. Government will go out of business. Deficit spending must stop. Mr. Speaker, I urge my colleagues to channel their energies and their thoughts toward this goal in the opening days of the 99th Congress. It is not too late to solve the problem. This Congress should be the one to solve it. Thank you, Mr. Speaker, and my distinguished colleagues for your clear understanding of the issue that is facing the nation. The budget must be balanced. Okay. This is a legal straight matter. Okay. For the record, let me, whoops, sorry. Let me suggest that it looks to me as though it is a situation where the declaratory, oh, is it Monday or what? Let's try again. For the record, let me suggest this. It looks to me as though it is a situation where the declaratory relief action ought not to have been filed. Now, the only way to get something off or out of the record that I don't believe in the first place ought to have been there in any case is to dismiss it. First, in behalf of Fisher, I have to get rid of his default. So if I set aside his default, as I just did, and it appears that even from Fisher's point of view, the court would be in error in permitting the plaintiff to continue to proceed in the declaratory relief action, and defendants, the Peters, have moved for judgment on the pleadings. It seems to me that the court might as well grant Fisher judgment on the pleadings. I don't think that is the right way to do it. The right way to do it would be, of course, for Allman to dismiss the declaratory relief action. And you would have all of the same things preserved intact for the tort action. So maybe instead of granting a motion for judgment on pleadings, it should be an order dismissing the action on the theory that the circumstances in the case appear to be such that a finding in the main personal injury action would cover the questions raised here. In order to avoid the duplication of effort and the duplication of hearing these matters, the matter of declaratory relief action is simply dismissed. It seems to me that is the way to do it. I think that dismissing it leaves everybody intact, whereas judgment on the pleadings is, in effect, a judgment that those things which Fisher ought to be alleging here, but hasn't as yet, are in fact true. There is no way to find that those things are true and give Fisher that benefit. The most we can say is that Fisher is entitled to defend in the tort action. So the order is as follows. The default of the defendant Fisher is vacated and set aside. Defendant Peters' motion is to dismiss is granted. The court on its own motion grants a dismissal in favor of Fisher. That ends declaratory relief actions. At this time, I have no citation that I can offer you at all for this decision. I think the best citation is the wording of the statement of the law as it is contained in the Lally case. The Lally case is a good example to read and look at it. I urge counsel to review it during the break. Now, we are simply down to the question of, does Allman believe that they have got to have the right to do this? If they do, then you have something about this declaratory relief action and get some law on it. It may be that I don't have the authority to do it, but that is what I think my authority is, and that is what I intend to do. So the motion for judgment on the pleadings, which was continued to today, is actually denied, and the motion to dismiss as to both Fisher and Peters is granted, the motion in behalf of Fisher being made on the court's own motion. Now, you all have to figure out what you want to do from here on out, and then you can call and try to work it out. If you can't agree on it, send it in, and I will follow through with it myself. Then we can meet at another time for a follow-up discussion and maybe some type of resolution. Okay, this is a jury charge on perjury. For the record, ladies and gentlemen of the jury, any person who declares under penalty of perjury and willfully and knowingly states that certain material facts are true, which one knows to be false, is guilty of the crime of perjury. Perjury is the willful telling of falsehoods while under oath. Perjury is the breaking of an oath or formal promise, whether oral or written. In our system of justice, each witness is asked to affirm or to swear to tell the truth. Our normal oath is preceded by the witness being asked to raise the right hand. This symbolizes the taking of a promise or a vow. The witness is asked, do you solemnly swear, or do you affirm to tell the truth, the whole truth, and nothing but the truth? If the witness answers in the affirmative, the penalty of perjury applies if misrepresentations and falsehoods are given during the testimony phase of the trial. Ladies and gentlemen of the jury, this process takes place in courtrooms across the nation on a daily basis. The swearing in or affirmation process is taken very seriously by the state court examiners and carries with it the solemn vow on the part of the witness to tell the whole truth and nothing but the truth. In order to be able to prove the commission of the crime of perjury, the following elements must be proved to the satisfaction of the court and jury beyond a reasonable doubt and to a moral certainty. 1, that such person declared under penalty of perjury that the identifying information that was given was true and correct. A person must rely on one's own judgment in how he will answer a question and the manner in which he will explain the evidence. 2nd, that the declaration under penalty of perjury is permitted by law. Although some states vary in their interpretation of statements given under penalty of perjury, the law is very narrow in its definition of the commission of perjury. 3rd, that a person declared as true a matter which he knew at the time was false. The person giving the testimony may be impeached by his own testimony given at another deposition, hearing, or trial. The person giving the testimony may be impeached by testimony given by another witness, although this process is not as obvious and may not be as effective. 4th, that such person had the specific intent to make such a false declaration. The motivation for the statement or declaration does not have to be ascertained, nor does the person's reason for giving false statements have to be determined to prove that perjury has been committed. Ladies and gentlemen of the jury, if you find that defendant Laredo made these statements that have been charged, these statements are to be considered as material matters within the definition of perjury that was read to you here this morning in the courtroom. The statements given by defendant Laredo can be held against him in a court of law. Perjury is committed when false statements are offered as facts. It is up to you, ladies and gentlemen of the jury, to determine whether or not defendant Laredo has committed perjury while on the stand. The legal community takes the charge of perjury very seriously. Ladies and gentlemen of the jury, you have heard the definitions, you have heard the evidence. You may now retire to the jury room for your deliberations. Gentlemen, now that the jury has left the courtroom, are there any other matters that need to be taken into consideration before we take a short recess? Gentlemen, may I have your attention for just a few short reminders before we adjourn for the day. These papers need to be taken under submission and signed before both of you leave the courtroom today. Now, in addition, Ms. Clerk, please give counsel copies of the documents for signature. Once you've read the documents, please give them to the clerk. If you have any problems, let me know. I will be in my office on the 10th floor. You can see me there if you need additional assistance on paperwork issues. I wish you a good afternoon break. Okay, we'll do another jury charge and then we'll do some takes. Okay. Ready? For the record, good afternoon, ladies and gentlemen. We are ready to hear the conclusion of this case we have been hearing for the last couple of days. The charge I will commence to deliver to you should be considered as a whole. You shouldn't choose certain elements to pay attention to and others to ignore. In other words, no one charge is to be weighed apart from the other charges or viewed apart from the other charges. In this case, as in all civil cases, the affirmative of the issue must be proved. Proving the affirmative issue here is upon the plaintiff as to all of the affirmative claims of the complaint. The burden of proof then rests upon the plaintiff in this case. In a civil case such as this, a preponderance of the evidence is all that is required. By a preponderance of the evidence is meant such evidence as, when weighed with that opposed to it, has more convincing force. There are two types of evidence, direct evidence and circumstantial evidence. Direct evidence is that which proves a fact directly without any inference or presumption. It is evidence which, if true, does prove a fact. Indirect evidence is evidence which, even though it may be true, does not of itself conclusively establish the fact in issue, but allows an inference or presumption of its existence. There are two kinds of indirect evidence, and they are namely presumptions and inferences. A presumption is a deduction that the law requires to be made from a certain fact. For instance, there is the presumption that a defendant is innocent until that defendant is proven guilty. Unless it is declared by law to be conclusive, a presumption may be negated by other evidence, direct or not, but unless it is negated, the jury is required to decide in accordance with it. An inference is a deduction which the jury draws from the facts proved by the evidence and the exhibits. There is no legal presumption of negligence in a case such as the one presented here. Negligence is a fact which must be proved, like all other facts alleged by the plaintiff in this case. Thus, the happening of the accident we are concerned with, nor the filing of the complaint, nor the fact that the injuries have been sustained by the plaintiff, which stem from the accident, raises any belief of negligence. In your deciding the credibility of a witness's testimony, you should consider whether there are inconsistencies in the witness's testimony, whether his testimony may have been contradicted by other testimony, and whether the testimony is consistent with other statements established by the evidence. You may also consider the manner of the witness on the stand, the character of his testimony, the bias or prejudice he or she may have, the interest or lack of interest in the outcome of the case, the recollection, clear or unclear, of the facts in the case, and the opportunity the witness might have to know the facts testified to. Discrepancy in a witness's testimony or between his or her testimony and that of others may not just mean that he or she is not telling the truth. Failure of memory, like faulty memory, is a common thing. Two persons who see or hear an incident may see it differently. The importance of the fact in issue should be considered. That is, if it is a vital fact. A witness is presumed to speak the truth. This presumption can be negated, though, by the manner in which they testify, the character of the testimony, or by evidence to the contrary of his or her testimony which you find believable. If a witness who has been sworn before you has testified falsely to a material fact, then you may disbelieve his or her entire testimony if you are so inclined. If a witness has been found to be lying in one part of her testimony, it is wise to be suspect of the other parts of her testimony. The rules of evidence do not usually permit a witness's opinion to be received as evidence in a case. An exception to this rule exists pertaining to those whom we call expert witnesses. A person who by schooling, study, and work has become an expert in some art, science, or profession may give his opinion as to any such matter in which he is expert. You should view such expert opinion and should weigh the reasons given for it. You are not bound, however, by the opinions of an expert. Give them whatever weight, great or small, which you deem entitled to. You may reject such opinions entirely if, in your judgment, the reasons given for the opinion are unsound. The defendant here is on trial solely upon the charges of the indictment, and in finding his guilt or innocence upon the charges, you are not to consider whether or not he may or may not be guilty of some charge which is not contained in the indictment. In determining the question of the guilt or the innocence of the defendant, you should consider all of the evidence in the case, meaning both the evidence brought on behalf of the prosecution and the evidence produced on behalf of the defendant. You will have in this case the duty of judging the truth of the witnesses and the weight that shall be given to their testimony. With that, the court has nothing to do. That is as solely within your province as it is within the province of the court to determine the questions of law. You may judge the credibility of the witnesses by the manner in which they testify. You may believe all or not at all that a witness has testified to. You may believe or disbelieve a part. It is for you to give credit to those witnesses who, in your opinion, are entitled to credit. You should know what the attorneys said to you in their opening statements or what they have said during the course of their arguments is not to be accepted as evidence by you. Got up to 220, finished at 210. Ready for takes? Yes or no? Or do you want more? You're okay?